Hello everyone, my name is Renato Costa, this is Aussie Law, and today we will talk about section 92 of the Australian Constitution, but this time we'll be focusing on a particular case. The case is called Cole and Whitfield from 1988. If you have not watched our previous video about section 92 of the Australian Constitution, now is the right time to stop this one here, watch that one first, and then come back. I'll be here, I'll wait for you. In our previous video, we saw the elements of section 92, and we also talked about the first interpretive approach adopted by the High Court of Australia. That approach considers section 92 of the Australian Constitution as an individual right. But this all changed in 1988 with the High Court decision in Cole and Whitfield. So let's take a look at this case and let's start with the facts. There was this act called the Fisheries Act from 1959 from Tasmania. The act empowered the executive to regulate the possession of crayfish in that state. And so the sea fisheries regulations regulated some aspects of the possession of crayfish in Tasmania. Particularly, Regulation 31(1)(d) prevented the possession of crayfish under a certain minimum length. All female crayfish should be over 105 centimeters and all male crayfish should be over 110 centimeters. So Whitfield was this crayfish trader who was charged with the unlawful possession of undersized crayfish in Tasmania. He had imported that crayfish from South Australia. The thing was that the size of the crayfish was in compliance with the South Australian regulations. So it did respect the minimum length according to the South Australian regulation, but it was not in compliance with the Tasmanian regulation. According to Tasmanian law, that crayfish was undersized. So Whitfield challenged the Tasmanian law as contrary to the freedom protected and expressed in section 92 of the Australian Constitution. The question that the High Court of Australia then had to answer was whether the Tasmanian law imposed a burden that somehow was contrary to section 92 of the Australian Constitution and the freedom of interstate trade and commerce. Was Regulation 31(1)(d) impermissibly discriminatory? The High Court decided unanimously that the law was valid. Although the regulations did impose a burden, the Justice of the High Court of Australia found that that burden was not discriminatory against the interstate trade and commerce. This decision is paradigmatic because it seems to solve one problem that the individual rights approach could not solve: how to conciliate section 51(1) of the Australian Constitution with section 92 of the Australian Constitution. By valuing the history and the original meaning and intention of the provision, the High Court said that the purpose of the section is clear enough: to create a free trade area throughout the Commonwealth and to deny to Commonwealth and states alike a power to prevent or obstruct the free movement of people, goods and communications across state boundaries. That is, trade and commerce are free from certain legislative burdens that constitute what was called discriminatory burdens of a protectionist kind. As the justices put it, to construe section 92 as requiring that interstate trade and commerce be immune only from a discriminatory burden of a protectionist kind does not involve inconsistency with the words absolutely free. It is simply to identify the kinds or classes of burdens, restrictions, controls and standards from which the section guarantees absolute freedom. And further, they affirmed the provision conferring legislative power, section 51(1), and the provision restricting the exercise of legislative power, section 92, sit more easily together if the latter is construed as being concerned with precluding particular types of burdens, such as discriminatory burdens of a protectionist kind. What the justices were saying was that the individual rights theory was unable to identify which kinds of burdens impermissibly breached section 92 and the absolute free expression in that provision. In Cole, under the free trade approach, this historical interpretation of Section 92, it was now possible to identify which kind of burden would be prohibited by Section 92. And this was called the discriminatory burden of a protectionist kind. Now, what does that mean? This refers to a burden on interstate trade and commerce that directly or indirectly discriminates against one state to protect another. They are restrictions that operate to protect the local businesses and industries from interstate competitors. As the High Court said, a law will discriminate against interstate trade or commerce if the law on its fact subjects that trade or commerce to a disability or disadvantage, or if the factual operation of the law produces such a result. So the decision of the High Court in Cole was that the regulation was valid because it did not distinguish between the internal or the external trade of produce. Any crayfish in Tasmania had to be of a minimum size, and it didn't matter where it came from. That is, the regulation was valid because it lacked a discriminatory burden of a protectionist kind. Although the limitation on the size of crayfish that may be sold or possessed in Tasmania is unquestionably a burden on the interstate trade and commerce in crayfish caught in South Australian waters and sold in Tasmania, the prohibition against the sale and possession of undersized crayfish apply alike to crayfish caught in Tasmanian waters and to those that are imported. In that respect, no discriminatory protectionist purpose appears on the face of the law. This is why the new approach is called the free trade theory. It seeks to bring back the ideal of a free trade throughout Australia by preventing states from imposing non-fiscal trade and commerce burdens that discriminate against another state. With the decision in Cole and the creation of this new approach, the free trade theory, it also came a separation of two limbs in Section 92. In Cole, the High Court of Australia separated the trade and commerce limb from the intercourse limb. You see, if the content of the intercourse limb is the same as the free trade and commerce, then it looks redundant. So for the justices, the expressions did not overlap, and the content of one could not interfere with the content of the other. As the High Court decided, the content, the notions of the expressions in trade and commerce and intercourse, they were distinct. And neither the history of the clause nor the ordinary meaning of its words require that the content of the guarantee of freedom of trade and commerce be seen as governing or governed by the content of the guarantee of freedom of intercourse. What are the repercussions then to the separation in terms of states closing its borders, for example, in the middle of a pandemic? This is the topic of our next video. Hey, I hope you enjoyed this one, and if you did, click the like button, subscribe to our channel and hit the bell icon, because my next video will talk about Section 92 in the intercourse limb, and we will discuss the closing of the borders during the pandemic. I'll see you soon. Until then, ciao.